Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in our country over the past week or so. And as is the norm, I want to begin by extending greetings to all of those who are joining us from Region 5 on television, from a hiker to West Coast Berbice. Welcome and good evening. Across the Berbice River, I want to welcome all of those who are joining us on television on the east bank of the Berbice River and right across the length and breadth of the Quarantine Coast from Kanji all the way to Molson Creek. And most importantly, the tens of thousands of you who are joining us live on Facebook right across the length and breadth of Guyana, the Caribbean, North America, Europe, further afield. Good evening and welcome to another program of Issues in the News. And to all of our listeners who are joining us on Freedom Radio from Rob Street, Georgetown, welcome to another program of Issues in the News. And this program, the viewership, I must say, is increasing every time this program airs. I'm looking at the number of persons who are joining us on the Facebook Live alone, and it is amazing. Tara Sobrian from Florida, Ann Hill, Rani Hussein, Parvati Parbu, Bansi Prasad, I saw Debbie Prasad earlier, I saw Neetu Maraj, Meena Budram, persons Patrick Narayan, I believe this guy is from Canada, Netram Sukmangal from Brooklyn, Agnes Isaacs, Nalini Subachan, Ramchan Mangal, Mohammed Imandin, Mahadev Prasad, good night. So the viewership is increasing tremendously as the clock is ticking. And as usual, I invite you to share this program so that all the persons who are following you and who are your friends and your fans on Facebook can join us in this important discourse. Press that share button on your phone or on your computer to invite and to share this program to all the persons who are your friends and your followers. Bansi Prasad watching from Brooklyn, New York. Romin Hiralal watching from Canada. Jormain Gentle. Rajin Balasar, Sorsati Garip Prasad from the USA. Dharam Raj Budu from Canada. And the crowd continues to build. Thank you very much, all of you, for joining on this program. And I ask again that you share the program so that as many persons as possible can join with us. COVID-19 continues to be a challenge right across the globe, and Guyana is no different. We are continuing as a government to put our best foot forward. Our health workers are leading from the front, and I want to take this opportunity to congratulate them for the tremendous job way beyond the call of duty that they are extending to the people of our country, ensuring that we keep the battle on against this deadly virus. We continue to do outreaches from the Ministry of Health to ensure that our people remain accessible so that they can be vaccinated and they can receive the boosters. Persons, very few in numbers, continue to criticize the vaccination program. We simply have to ignore them. The data and the literature from the experts do not support their rantings. They continue to dissuade persons from taking the vaccine, but we have to continue to try to educate people. The cold hard facts are that the largest number of deaths are persons who are unvaccinated, and that fact cannot be disputed. We are experiencing the success of the vaccination program. You would know that the latest strand of the virus is not as devastating as its predecessors were, and in my humble view, that is because the vaccines are working. So we will continue to strive as a government to ensure that our population is vaccinated. We encourage teachers to join the tens of thousands of our citizens who have already been vaccinated. Your health is important. You are expected to take our students to the next academic and intellectual level, and therefore you owe a duty to the children in our schools to ensure that you are healthy and you remain strong so that you can deliver the type of learning that our children deserve. I know that there have been attempts to politicize the COVID vaccination program, and that continues to be a horrible and most unfortunate campaign strategy by some politicians. I hope at some point in time they will desist. The truth remains that they are vaccinated. We know that. We have the medical record. They are vaccinated, but they continue to attempt to mislead others and to persuade others from not receiving and getting their vaccines. It is the most callous, cruel, and inhuman type of behavior that I've witnessed in recent times, but certain politicians continue to do so with comfort and without any problems or any conscience attack whatsoever. But the government will continue, and we will continue to ensure that our business community and continues to succeed in their endeavors, and that the country remains as normal as possible. Over the past few days, two Guyanese icons have died. I speak of Balram Singh Rai and Dr. Esu Asad. I have paid tribute to both of these gentlemen on my Facebook page, and I just want to reiterate those sentiments. Both of these men, they lived a very full life. Balram Singh Rai died at the ripe old age of 101, and Dr. Esu Asad died at age 93. They both lived very long lives, and their lives were punctuated with distinguished accomplishments. They were both professionals in different professions. Balram Singh Rai was a barrister at law, and Dr. Esu Asad was a chartered accountant. They are both products of the low G, and for them to have traveled to England, and for their parents to have had the vision and the wherewithal to finance them and to send them by boat to England to receive professional education, and for them to have successfully received that education is by itself and without more a remarkable achievement. They would have gone to England in the 1940s or even before, and they would have studied and lived under very, very trying circumstances in an alien land, having come from the Logi and the latrines of Guyana. I believe that one must salute these men for what they have achieved. Balram Singh Rai entered politics. His stint was one that was controversial. He was, however, a member of parliament of our country. He was a minister of education. He was a minister of home affairs. He played a role in the fight for Guyana's independence. He traveled with the independence delegation to London during the early 60s, and would have been the last person from that epoch of our history who survived this long. As I said, he left Guyana and returned to live in England, where he died. He never returned because of certain bitter experiences that he had with Guyanese politics. Be that as it may, I don't want to get into controversy. I believe, however, that he has made a contribution of worth. Dr. Esu Asad, his contribution is extraordinary. I said that he was a leader in the business community, in not only in Guyana but in the Caribbean, and he was recognized in Guyana and across the globe by several organizations for his remarkable and outstanding contributions in the area of business, commerce, culture, politics, and even in other endeavors, banking, etc. He was the pioneer of the Demerara Distilleries Limited. That company, under his stewardship, was built into a multi-billion-dollar empire with a brand that enjoys international distinction. The rum produced by this company has won awards and rewards right across Europe and in many other parts of the world. Dr. Esu Asad also was the founder of the Demerara Bank, our first and only privately owned indigenous bank. He was the intellectual author of organizations such as Trust Company Guyana Limited, the first of its kind in Guyana, and IPED, a small organization that financed the small man in his business endeavors. So his vision, while was huge and grand, did not exclude the common man, and he provided a source of financing for the common man as well. And he has done much more. He was the founder of that organization called GUARD that played quite a fundamental role in the restoration of democracy. I recall as a child going to rallies in 1989, 1990, 91, held by GUARD right across this country, where Dr. Esu Asad spoke fearlessly against the PNC dictatorship and championed bravely for the return of democracy and for the reforms that came during that period, which ensured that democracy was returned to Guyana and free and fair elections were eventually held. Things like a new elections commission, things like counting the ballots at the place of poll, when Des Moines said to do so would be a logistic nightmare. That was the phrase that he used to describe it. The securing the presence of the Carter Center and other international observer groups to the country, and the reformation that was done to the Guyana Elections Commission. Esu Asad played a role in the attainment of those objectives. I met him just a few months ago at the headquarters of the Demerara Bank, and I sat with him. We spent about 30 minutes or more together. He was mentally agile. He was a little physically feeble, but the conversation, as usual, was gripping, and he told me about his life in England and the number of countries that he visited and some of the hurdles that he faced, but that he persevered with his vision, and he did so fearlessly, and he did so in his own way. And for that reason, he must be considered an icon by any standard, and he was globally honored for his tremendous and remarkable contribution in so many endeavors of Guyanese life and even broader in relation to other societies. So I want, on behalf of this program, Issues in the News, to once again convey to the relatives, to the friends of these two stalwarts, these two icons, my deepest condolences. And I want to do so also on behalf of the government of Guyana, and I also want to do so on behalf of the People's Progressive Party Civic, of which I am an executive member. Today, we had a I want to deal a little first with the ruling of the High Court in relation to the granting of bail. You would recall that an aeroplane coming from Brazil landed at Oriala up the Quarantine River, and 2 Brazilians were found in the aircraft, and the aircraft was loaded with cocaine. They were arrested and placed before the Skeldon Magistrates Court, charged with the offenses of trafficking of narcotics and unlawful entry into Guyana. These men had no status in Guyana. They had no permission to enter Guyana. They did not even have passports. They appeared before a learned magistrate in Perverse, and his name is now public, and they were granted bail, though the narcotics law says very clearly that bail shall not be granted unless there are special circumstances, the burden being on the defendant to establish those special circumstances. The term special circumstances have been interpreted by our courts to mean that they must relate to the defendant, they must relate to the offense, the facts and circumstances of the offense, and not the offender. The learned magistrate who grants bail must record those special reasons. This magistrate granted bail in very minuscule sums. Quite apart from the prohibition contained in the Narcotics Act against the grant of bail, this learned magistrate, in essence, was, by his order granting bail, releasing these 2 Brazilians back into a country where they have no status, where they entered illegally, and they had no permission to remain in the country. So when they were released on bail, every minute of the day that they spent in Guyana would have constituted another breach of a series of offenses, being unlawfully in Guyana, etc., etc. So you would have had a perpetual commission of offenses because they are illegal in the country. That thought did not enter the mind of the magistrate. Or if it did, he excised it from his mind. In addition to that, the special circumstances that the learned magistrate recorded were, 1, there was an outbreak of COVID in the prison, and 2, that there was overpopulation in the prisons. Now, neither of these 2 reasons relate to the offense. As I said, special circumstances have been interpreted to mean by our judiciary circumstances that must relate to the offense and not the offender. If there is an outbreak of COVID in the prison, it has nothing to do with the offense. It has nothing to do with trafficking of narcotics. If If there is overcrowding in the prisons, that has nothing to do with the offense of trafficking of narcotics. So the special reasons proffered by the learned magistrate were no reason at all, certainly not special reason as contemplated by the law. So I have been critical, and many members of the public have been critical of the grant and refusal of bail by magistrates. And I even penned a letter in the newspapers some time ago in which I indicated that the state will consider challenging orders granting bail where the state believes that those orders are not in accordance with the established principles of law regarding the grant of bail. I said that wherever these grants of bail appear to be an abuse of discretion or a wrong exercise of discretion in relation to the grant of bail, the state will have to consider challenging them. I was criticized in some quarters. I recall there was one lawyer, a senior counsel, who criticized me to the effect that as a minister, I must not criticize the judiciary. Well, I don't hold that view. The judiciary, as I've often said, must suffer the scrutiny of the ordinary man. The judiciary is not a cloistered virtue. The judiciary is a public institution funded by public monies and therefore must be subject to public commentary, even critical public commentary. What one is prohibited from doing is to attribute an improper motive to the judicial tribunal. And I have never done that. And I will not do that. But I will exercise my right to free speech, and I will exercise my right to criticize a decision of a court with which I am not in agreement. And that is the law of this country, and that is the law of the civilized world. So this case presented itself. So you had this magistrate granting bail to these two Brazilians, and the state, the Attorney General, first of all got a stay of execution against the bail orders. I got what is called a writ of prohibition, prohibiting the order from being executed. So they were never released on bail. They were kept in the prison. And I also sought what is called a writ of certiorari to quash the decision of the learned magistrate. And those proceedings were filed, and the judge heard submissions. The accused persons were represented. Mr. Nigel Hughes appeared along with some other lawyers, and we had detailed arguments, and we filed pleadings, and we did a lot of research, and the judge in the end upheld the submissions of the state. And the judge in his ruling went through the law and very clearly established the various breaches of the law committed by the learned magistrate and how the magistrate erred in the exercise of his discretion in granting bail in those factual circumstances. And the learned judge concluded that the decision of the learned magistrate was perverse. That is the language that the judge used. I didn't use that language. That is the language of the judge. This is the first time that the state in Guyana, and from my research, the Caribbean, has challenged the decision of a magistrate granting bail. This will not be the last one. The state will remain vigilant to ensure that in all proceedings, including criminal proceedings, the public interest is protected. Oftentimes, people think that the judicial process is a one-way street where only the rights of the accused person must be protected. That is wrong. Justice is a two-way street where the rights of the victims, the rights of the state, and the public interest are all on one side, and the rights of the accused persons are on the other side. And the scales of justice must balance the two. The accused is offered certain fundamental protections by the law, and he must get that. For example, the presumption of innocence. He must get that. But the state's interest must also be protected. The rights of the victims must also be protected. That is why I am often critical of the Guyana Human Rights Association. I have never in recent, I cannot recall a single incident in recent memory where that organization has ever called for justice in relation to the victim of a crime. But let the police harass or shoot or anyone harm the alleged perpetrator of that crime. And this organization and many of its ilk would come out with condemnatory public statements. But you have had the various massacres, you have had the most tragic violations of human rights, where victims are raped, mutilated, brutalized at the hands of alleged criminals, or criminals if you wish, and these organizations are quiet. But when the alleged accused or the alleged criminal is in some way injured, harassed, shot at, or beaten by the police or by public-spirited citizens, these organizations come out. Now, I am not saying that the police is right to shoot any person. It depends on the circumstances. The police, of course, has a right to use legal force, lethal force as well, in appropriate circumstances. That is the law of this country. Persons are right to use violence in self-defense and in defense of their property. That is the law of this country. All I'm saying is that when these organizations make their condemnation, they must do so even-handedly. They must not do so in a manner that conveys the impression that they are only concerned with the interest of one side. That cannot be the law. That can't be fairness. That can't be equitable. That can't be just. That can't be the principle. So, in this case, the learned High Court judge vindicated the state's position. And I consider this judgment to be a landmark judgment. It was well researched and very eruditely presented by the learned judge. Copies of it will be available, I am told, tomorrow, and once available, will be made public. And I invite interested persons to get a copy of it because it makes interesting reading, certainly based upon the oral presentation of that judgment. It, as I said, it captures the law and it shatters a lot of myths that surround people's perception of what the law is. It's a good judgment and it will go down in our legal books as an outstanding decision at a time and a juncture when it is required in the jurisprudence of our country and in the legal system of our country. Somebody is asking me, can you touch on the language used to describe the decision of Justice Moore by Justice Kissoon? Well, I've quoted the language, and Justice Kissoon is the judge. He must have basis for saying what he said, and he said it, and I've repeated it. I am diverting a little just to keep you engaged because I realize that a lot of people want this program to be interactive. Sandra Ali from New York is watching. Banmati Bihari is watching. Navi Chan, maybe post it to the Ministry of Legal website. I will do so. Navi, Henry Singh. Yes, Henry, I'm reading your comment. Chaman Singh is watching. Lisa Sundar. The comments are spinning so quickly, it is difficult to read them because the writing is small. I'll try to get an iPad on the next occasion, and I can be able to read more fluently and with greater ease. Another important event that took place today is the ruling of the Guyana Court of Appeal. As you know, we filed an appeal, the Attorney General and Bharat Jagdeo as General Secretary of the People's Progressive Party. We filed an appeal against the decision of the Court of Appeal, in which the Court of Appeal ruled that it had jurisdiction to hear and determine the elections petition of Monica Thomas that was dismissed by Chief Justice Roxanne George for non-service. We filed an application, as we are required to do, as a first step towards appealing, and that application was for leave to appeal that decision of the Court of Appeal to the Caribbean Court of Justice, because the rules of court require that to be done. And we also requested the court to grant us a stay of execution, meaning that it must not proceed to hear and determine the appeal until our appeal is heard at the Caribbean Court of Justice. I pause here to make the fundamental point, because I have seen many persons criticizing the decision of Justice George, saying that the petition should have been allowed to be heard, and that it's unfair to strike the petition out without hearing it on its merits. I have countered, and I will reiterate it again, that litigation carries with it certain rules. And unless those rules sometimes are condition precedent for the exercise of the court's discretion, jurisdiction rather, to hear the particular case. What that means is that if you don't follow those rules, your case may not be heard. And that is not only the position in Guyana, that is the position across the world. Wherever there is an orderly society and there is a civilized legal system, it has rules that governs how you approach the court in particular cases. The rules may differ based upon the type of case that you are presenting. So, take for example, in this matter, an appeal could not have been filed straight away to the Caribbean Court of Justice because the rules do not permit that. The rules directed rather that we must go to the Guyana Court of Appeal first and get leave to go to the Caribbean Court of Justice. We had to comply with that directive. Similarly, those who filed the petition had to comply with certain directives. They had to serve the matter within a prescribed time frame. And the law says that if that is not observed, then a judge can strike the petition out because no court has a jurisdiction to hear an elections petition that is not properly served. It's the same type of rules that we have to comply with. For example, had we gone straight to the Caribbean Court of Justice without seeking leave of the Court of Appeal, Mr. Roysdale Ford and his team could have asked for our appeal to be dismissed, and the CCJ may have been dismissed it once they were able to convince the court that they are right. I say that so that you understand and we do not continue to make uneducated comments and vexatious criticisms against certain decisions of judges and so on. That is the nature of the system. We had to comply and follow a particular procedural route to arrive at our destination, which is at the Caribbean Court of Justice. We couldn't short circuit it, and we studied that route, and we went by what we consider to be the right approach. And it turned out to be right, because the Court of Appeal granted us the leave that we were seeking and granted us the stay of execution. But down in the court below, those who were prosecuting that petition did not comply with the rules governing the prosecution of the petition in the court below. I hope people understand how the law works, so that when the certain decisions are made, you can put them in perspective. Not all decisions, some are plainly perverse, as I've often pointed out here. And I've made reference to one earlier, which the judge said was perverse. So it means by that ruling that the way is now clear for us to proceed to file our appeals to the Caribbean Court of Justice, and certain directions again were given to us in terms of time frame. We have to prepare what is called a record of appeal within 90 days and file that and serve that on the other side, and then we will get further directions from the Caribbean Court of Justice in terms of the appeal going forward. So the case is going forward, and we will hear what the Caribbean Court of Justice has to say in relation to the ruling of the judges of the Guyana Court of Appeal on this matter. So we don't have to wait very long. That ruling, that matter will commence shortly before the Caribbean Court of Justice. Somebody is asking what is the latest on the electoral reforms. As I have repeatedly said here, one set of proposals are out there in the public domain, and those are the proposals that relate to ROPA, the Representation of the People's Act. We are working on another set that relates to registration of electors. That set is even more complicated. The work there is a little more tedious, because the material that you have to examine is of a wider magnitude and a little more complex than the ROPA. That is a work in progress, and as soon as it is completed, it will be made public in the way that the others have been made public. I want to speak a little on a meeting we had, two meetings that we had today in the National Assembly. We had a meeting of the Constitutional Reform we had a meeting of the Standing Committee on Constitutional Reform today in the National Assembly at 9 a.m. As you are aware, I am the chairman of that committee. That committee met, I believe, twice before, but not much was accomplished, and I wish to convey the committee's collective regret for not meeting with the regularity that we should have met during the course of 2021, and that was due to a number of factors, including the speaker being infected with COVID-19, the parliament staff being affected with COVID-19, the parliament being shut down for periodic intervals, among other things, and of course, a busy schedule for all the members of the committee. That being said, This year, it is expected that the committee will work with greater expediency and efficiency. We had a very good meeting today. At the meeting, we began to work on the work program or the agenda, well, yes, the work program of the committee. That is to say, how the committee will do its work going forward. All parties in the National Assembly have promised constitutional reform in their manifestos, so I don't anticipate any great resistance in terms of the agenda going forward. This is one committee that will require necessarily consensus if anything substantive and substantial is to be achieved, and that is because of the very nature of constitutional reform. Any provision of substance that requires reform or that is identified for reform can only be amended by a two-thirds majority minimum. That means that we have to have bilateral cooperation in the parliament at a minimum, bilateral between the two major parties. So we will have to have a lot of consensual decisions going forward, and I made that very clear to the committee. Significantly also, the committee has begun to amass all the work that was done by previous committees. That is to say, our immediate predecessors, that would have been the Standing Committee on Constitutional Reform in relation to the 11th Parliament. Recall that a constitutional reform bill was tabled and sent to that committee, and that committee had begun some discussions. All those materials are now being collected. We are also looking at the modus operandi used and the modalities used by the Constitutional Reform Commission of 1999 and 2001. That commission was formed by way of an act, a Constitutional Reform Commission Act of 1999. That act has been received and will be reviewed along with the bill that I'm speaking about. And there are certain recommendations that came out of that 1991 to 2001 process that were never implemented. We are accumulating those amendments and grouping them together so that when we begin to discuss our work program and how it will manifest itself, we will have all this material or all these materials available. Significantly, what I believe all the political parties have agreed to is a publicly consultative engagement. So I don't think that that issue or that part of the work program will evoke any controversy or disagreements. I believe that all the political parties in their manifesto promised that the engagement in relation to constitutional reform would be a public one, one would involve all the important stakeholder organizations in the country in a consultative engagement. I will speak more about that issue as we go forward with the work of the committee. A date has been fixed for the next meeting, and the task would have begun for the work, the gathering of the documents and information that were identified. The task would begin to do so, to gather them together. Today also, we had a meeting of the special committee on the amendments to the Narcotics and Psychotropic Controlled Substances Act. recall that a bill was tabled pursuant to our manifesto promise in the National Assembly in 2021, and that bill seeks to amend the certain provisions of the Narcotics Act with the intent of removing custodial sentences from persons being found in possession of small quantities of marijuana, that is to say, 15 grams and above, from 0 to 15 grams, and then from 15 grams to 30 grams. If a person is found with 0 to 15 grams, then the bill proposes counseling, and if it is from 15 to 30 grams, then the bill proposes community work. So persons will no longer be sent to jail for possession of those quantities of narcotics. Of course, we are delivering on our promise. The APNU AFC made a similar promise. They even brought a bill to the National Assembly, which they killed themselves. They never brought it forward. We are delivering, and I just want to pause there to show the difference between the two political parties. We are delivering on our promise, and today the committee met for the second time. I'm the chairman of that committee as well, and we began the discussion of a work program. We decided that we will invite by public advertisements or by public notices members of the public to make their submissions in writing to the committee, and time frames will be set out in those public notices. And at the next meeting, providing that we receive the requested submissions, those submissions will be reviewed, and then the committee will determine whether we would like to hear oral presentations from any of those who chose to submit in writing. And if, for example, an important stakeholder organization may have omitted to make any submissions in writing, we will consider writing to that stakeholder organization to ensure that those organizations have an input. So work has begun in that committee as well, and hopefully we will accelerate the works in those committees. In due course, of course, we have the budgetary process that will intervene shortly, and that will put a temporary pause on the work of those committees. I want to take this opportunity to compliment the President, His Excellency Dr. Mohammed Irfan Ali, and the government of Guyana, along with the Private Sector Commission, the Army, the discipline forces, and members of the public who have launched a massive clean-up campaign of Georgetown. The President is leading from the front, and I want to salute His Excellency for that type of initiative and the fact that he's leading from the front on the ground. Remarkable progress has been made. Speaking for myself, it's unfortunate that I've been unable to participate in this component of the exercise, but it is an ongoing process. As you may have observed, I was on the East Coast doing a COVID-19 outreach program at the same time when this was ongoing. But I salute my colleagues in government and the private sector, the Army, the discipline forces, and members of the public in this wonderful collaboration. We have to do this on a more regular basis. I want to condemn in the strongest possible way the outrageous and ridiculous utterances of His Worship the Mayor, Yubraj Narain, who criticized the who criticized the initiative. This guy is unbelievable. He is the mayor of Georgetown, the mayor and city council of Georgetown has a statutory duty under the Mayor and City Council Act and the requisite bylaws to do the very work that this confabulation decided to undertake. And rather than complement this initiative, rather than support the initiative, or better yet, join the initiative, and that initiative was only undertaken because of the neglect of duty and the breach of statutory duty, which is an offense, by the mayor and the city council. That's the only reason why this initiative is being undertaken. And this gentleman sees it fit to criticize this issue and perceives it to be an undermining of his authority and the authority of the council. These are not sensible statements. They can't come from an intelligent mind. And political invectives were introduced and used by the mayor in his outpourings against this initiative. And what is even worse is what I consider to be a deliberate strategy and ploy, centrally directed, to sabotage the work of this organization or this unit that has been assembled by littering the areas that have been cleaned. This is a type of callousness. This is a level of ignorance. This is a different type of foolishness. This is not ordinary clumsiness that I'm seeing here. And I am happy that with the use of technology, some of these miscreants have been caught on camera and are now before the courts of our country. This type of behavior must never be encouraged. Must never be encouraged. I can't believe that persons who live and dwell in the city were actually relittering, and deliberately so, for the purpose of sabotaging the efforts, the areas that were already clean. I don't understand. I really don't understand the type of mentality that would do such thing, and the perversity of mind that would conceive a plan to unfold such a strategy. I don't understand the quality of mind that is capable of that kind of rubbish, and that's the proper word to use in the circumstances. I see Janet Lal is watching. Hansraj Prasad is watching. Avinash. When will Parliament resume? Parliament is not in session as I speak. Parliament has resumed, and we will have a parliamentary session soon, parliamentary sitting soon, and we will have many more parliamentary sitting soon. So I'm seeing Mustafa Dean, put them in jail and let them pay a big fine. I agree with you. I agree with you. These persons should be treated in the harshest possible way, and the most penal sanctions possible under the law should be imposed for this kind of foolishness. My operator is signaling to me that we have approached program time, so I want to thank you once again for watching this program. As I said, our viewership continues to build astronomically. So please continue to spread the word about this program. I will continue to try to bring important information to you. I know a lot of people in Europe and a lot of people in North America, in the Caribbean, and of course right here in Guyana and many, many other parts of the world are looking at this program. I normally get messages from communities in Holland, in Australia, in New Zealand, of persons who are following this program. So I want to thank you once again for your support over the years. This is a new year, and please let's build an even bigger viewership and a bigger audience, so that we can have a greater interactive session or greater interactive sessions. I will find some other way of communicating with you as the program unfolds in the months to come, either by WhatsApp or by some form of telecommunication. But we will continue to make the program exciting and interactive so that I don't necessarily have to be speaking all the time. You can have an opportunity to interact, to make the program even more interesting. I want to thank you very much for your time, and please take care of yourself. Enjoy the rest of this week. Stay safe, and I will see you again next week when we resume this important discourse. Thank you very much, and good evening.